Hey, Ms. Berger, I think you're up.
Good afternoon, Your Honors. My name is Erin Berger from Jossula. I represent the appellant Martha Arana in this case. I'd like to reserve 5 minutes of my time for rebuttal, Your Honor.
Sure.
Your Honors, Mr. Arana appeals to this court the finding that People's Trust Insurance Company is entitled to recover their attorney's fees and costs under Florida Statute Section 768.79 and pursuant to the proposals for settlement that were served in this case. We were previously before this court back in September. We had appealed the final judgment as well. The final judgment was affirmed by this court in September, but that's the issue with regard to the attorney's fees remains. People's Trust filed a motion for attorney's fees and costs based on the proposals for settlement served in August of 2018. And then a few months later, they filed a second or supplemental motion for entitlement to attorney's fees and costs in January of 2019 based on a March 2018 proposal for settlement.
The release does seem to indicate that future claims would be released, but isn't that qualified by the language that says, or in any way growing out of the claim or lawsuit? So future claims growing out of the claim and lawsuit.
With regard to the August proposal or the March proposal, Your Honor?
You know what? I hope you can help me with that because I'm just reading an excerpt that in my notes is not tied to which one. So.
Sure, and I apologize. They've become a bit muddled in my brain as well. But let me just say this.
I think that's the March. No way. I think that's the March.
Yeah, in the March proposal, there is a particular provision that says future claims directly, which even though there is that qualifying language in another provision with regard to the particular claim and lawsuit, under the Zalis case that was cited by Ms. Arana in her initial brief, that's a disqualifying ambiguity, and that proposal for settlement is unenforceable.
What's a disqualifying ambiguity?
That the proposal or that the proposed release required release of any future claims. So that's.
But what a release can't say, you know what, any present claims or future claims based on this lawsuit, and that disqualifies it from the statute?
With the language that was used, I believe it does. I'm fine trying to.
Any future claim brings it outside the ambit of the fee shifting statute. Any requirement of release of a future claim brings it out of the ambit of the fee shifting statute?
In terms of the language that was used, I'm looking at it here, Your Honor. It says suits of law or inequity rising out of or directly or indirectly from the claim and the lawsuit for any action relating to any purported breach of the policy that Arana has against PTIC. So I think the language is a bit more broad than just arising out of the claim in the lawsuit. It says for any action relating to any purported breach of the policy that Ms. Arana has for against the insurance company. But more importantly, the insurance company doesn't, even though they filed this supplemental motion, they didn't really rely upon this March proposal at the hearing or otherwise. They don't really make much mention of it in the answer brief either. And the judge seemed to only consider what was argued at the hearing in terms of the August proposal. But again, we still would rely on the fact that this language was ambiguous and disqualifying for the March proposal. The August proposal that was served later was thought to resolve, according to the proposal, all damages in this particular case. But the proposed release attached to it contained 2 paragraphs of release language, and it required the release of People's Trust from any and all manner of claims, actions, and etc. that the plaintiff ever had or now has against the defendant in this action. The next paragraph, which is preceded by the word and, required the release of People's Trust from any and all manner of claims, etc., that the plaintiff ever has or now has against the defendant, including but not limited to the claims raised in the lawsuit. And I think that that language there is what mostly qualifies as is the ambiguous, disqualifying language here. Under the case that was cited by Ms. Arana in the initial brief, Palm Beach Holdings versus Village of Wellington, the proposal for settlement was found legally deficient because an acceptance would have extinguished other pending and unrelated claims. And in that provision, in that case, that particular language was included in the release, that including but not limited to, and it was emphasized by the court in that decision, suggesting that prior to identifying, or that it identified other claims that were not brought and created an ambiguity between what was said in the proposal, that the release would be just as to this claim in this lawsuit, that it created this ambiguity that it could involve any other unrelated claims that the plaintiff had not yet brought, but could have. The including but not limited to language creates an ambiguity between the release and the proposal here, in that the proposal specifically says any claims under this lawsuit, but then the release requires Ms. Arana to release any claims, including but not limited to anything that she may have related to her property, related to this insurance policy, related to pretty much anything under the sun.
Now, I'm sure that the opposing counsel is going to say that was circumscribed by the language the previous language in the release that says ever had or now has in this action.
Right, and People's Trust does argue that we're injecting ambiguity where one does not exist. Certainly, that's their position. But the rule is strictly construed under all of the authorities that were cited in the initial brief, particularly the Florida Supreme Court cases, Nichols. Even if a harsh result seems to be, even if there is a harsh result or something that seems harsh, the rule in the statute must be strictly construed, because the party to whom the offer is made has to be able to make a reasoned and well-informed decision about their possibilities at trial, or whether or not they'll be able to, bring other claims in the future, or if they'll be able to maintain claims that they currently have. And the record here, does suggest in the response that was made to the motion for fees that she had other claims that were pending, perhaps not against People's Trust, but perhaps there was some confusion because she had other claims related to her property. So there is not only a patent ambiguity between the proposal and the release language, but maybe that
so claims against a party claims against an insurance company that's not a party to this offer creates a latent ambiguity.
Your Honor,
let me ask you this. So go ahead.
No, I'm sorry, I didn't mean to interrupt. But the way that the language is, it just states with regard to her property in general.
All right, leaving aside that anyway, but let me derail my own thoughts and go back to what I was going to say. There's two clauses, there's two sentences in the August settlement offer release. One says ever had or now has in this action, and it talks about it has a case number, a circuit case number. The other says ever had or now has, including but not limited to, and has a claim number. So if I am the offeree, I say, okay, this resolves my claim. Like this is my one shot. I filed case number 17 CA 1148 based on claim number 165924, and that's the whole ball game. I can't come after them for this claim. So why is that leave anything in doubt?
Your Honor,
in other words, the including but not limited to means, well, you may have whatever else was in your lawsuit, but we're going to be darn sure that it extinguishes this claim. Including or not limited to doesn't mean other things outside this lawsuit. It just means matters brought in this lawsuit, including or not limited to this claim. That's extinguished. So everything
nevertheless, that there could be litigation over that if she were to make another claim.
Correct, and that's
whether this language was strictly limited to that claim or not. Correct,
and that's the argument that Ms. Arana is making, in that technically that second paragraph probably wasn't even really necessary. If they had stopped at that, we might not even be here. But including that second provision, preceded by the word "and," makes it a requirement, and then includes anything that you have or now had or now have, including but not limited to anything that you've already brought. But the proposal
including but not limited to.
Exactly.
Right.
Exactly. And the proposal specifically says damages related to this claim. So that's where the ambiguity is, in that the proposal doesn't suggest that it's extinguishing all claims up to and including this point, which, other cases that People's Trust points out, that doesn't necessarily create an ambiguity. But here you have a patent ambiguity between the proposal itself and the release language.
I understand that. Let me ask another question. So the August settlement offer, though, correct me if I'm wrong, the settlement offer and the release, neither of them insinuate future claims. Is that correct? Although the March one does. So play the devil's advocate here. So if there's no language in the August claim, in the August offer and release about future claims, is it ambiguous to say any claims you've made up until this point, including CFL 16592 or others, and anything that you ever had or now have regarding case number 17CA 1148 in circuit court? If there's no insinuation of future claims, why is that ambiguous? In other words, anything you brought up to this point?
The argument was made in the trial court that the forever discharges language insinuates some future claims, but
Forever discharges what?
That
Present
preceded
claims.
forever discharges People's Trust, that preceded all the types of actions and claims and that type.
But what is that? What do you mean forever? But forever discharges something that exists now. Why is that? Why does that insinuate future claims that don't yet exist?
We didn't make that argument in the initial brief, Your Honor, but that was offered.
So going back to my question,
Right.
which
And
didn't have to do with an argument you didn't make in your initial brief.
Right, but I was getting there, Your Honor, and to
Okay.
suggest that the circumstances here, based on the previously offered proposal in March that did specifically say future claims, gave them, this mindset, or maybe created this mindset and ambiguity, in that she was still under the impression that she had to release future claims. It doesn't expressly say future claims in the August proposal as it did in the March proposal, but it does also have that additional, including but not limited to, language that may have involved other claims that she may have or had at the time. I'm not sure that answered your question, but the
But how many claims did she have against People's Trust?
according to the record, she only had the one against People's Trust. The rule requires all conditions and non-monetary terms be described with particularity. Releases that accompany a proposal are deemed part of that condition or in non-monetary terms. In the answer brief, the insurance company, went through the process of distinguishing all of the claims that were cited, somewhat for general purposes, but somewhat because they did involve different releases that were deemed to be unenforceable. But the analysis that's provided in each of those cases is applicable here, even if they are not factually on all fours. As I've mentioned, the Palm Beach Holdings cases is probably the most factually similar to the circumstance we have here. The Zales versus MEJ Rich Corp case, as in that case, the release was reviewed. The court reviewed a release that was construed to require relinquishment of any future claims, and that was more towards our argument with regard to the March proposal, Your Honors. The other cases that were cited demonstrate, again, that if there is any ambiguity, the entire proposal is deemed unenforceable, even if it might seem like a harsh result. The insurance company raised the decision of Allen versus Nunez, and that case is distinguishable in that it involved the ambiguity that's created when there's multiple parties to the lawsuit, and we don't have those issues here. So that case isn't necessarily applicable here, but it does, again, state the general requirements that a proposal is deemed or is strictly construed and must be, the rule in the statute must be strictly construed and enforced. Although I'm looking through my notes to make sure that I've hit all the arguments, and your questions have pretty much brought me to the point where I think I've touched on everything. People's Trust argues that it's satisfied all the requirements of the statute and the rule in terms of timing and description of the terms and conditions of the proposal. Contrary to the People's Trust arguments, Ms. Arana is not trying to inject an ambiguity where one does not exist, but points out at least a patent ambiguity that exists between the proposal and the proposed release. And I'll reserve the rest of my time, Your Honors.
Sorry. You have right about 5 minutes, Ms. Berger.
Good afternoon, Your Honors. May it please the court. Michael Rosenberg from Cole, Scott, and Cassane on behalf of the appellee People's Trust. The final judgment for attorney's fees should be affirmed because the trial court did not err when it determined the August 30th, 2018 proposal for settlement and release was not ambiguous and that it complied with Florida Rules of Civil Procedure 1.442 and Section 768.28 Florida statutes. What I've heard during the appellant's presentation are a lot of concessions that weren't apparent in the initial brief that even further buttresses People's Trust's argument that the proposal for settlement was not ambiguous. The first concession is that Ms. Arana did not have any other claims against People's Trust, and therefore any quote unquote ambiguity that was contained in paragraph 3 discharging the defendant would not affect any other insurance company or any other claim. And Judge Atkinson, you pointed it out very astutely that paragraphs 2 and 3 can be read together to both release any claims that Ms. Arana had or has, no indication of any future claims, or in a general release of the claim itself against People's Trust, and not as to any other entity, any claim that Ms. Arana had or now has.
Isn't it also permissible to read them separately? In other words, everything, every claim you had or now have in this action, but also any other claim. It says including or not any claims, including or not limited to. How does that narrow what is being released?
I mean,
In other words,
including but not
everything you brought
limited to actually seems to underscore the breadth of the previous paragraph, does it not?
What it does is it releases any claims that Ms. Arana had or has. So we have no supplemental claims that have been filed with respect to this claim number. So we're only dealing with the specific claim number, CFL 1654924, and the policy.
Then why does the release say, but not limited to those claims?
It's one of the arguments that I would raise is that when we're analyzing this paragraph, these arguments were actually never raised before the trial court. And I think that when you're looking between the two paragraphs, the intent and the realization before the insured is that she's releasing her claims against People's Trust. In the trial court, what was argued in the motion and then at the hearing had to do with the forever discharging language. And Judge Brody took that argument under consideration and agreed with People's Trust that it was not releasing future claims.
So assuming it wasn't releasing future claims, is it not permissible to read this release as requiring a release of claims that were not included in case number 17 CA 1148?
I don't believe so, because the claims that are part of that lawsuit that make up the lawsuit that went to a jury trial, to which the jury determined that there was no liability.
I'm just looking at the language. The language says in two separate locations in the document. One having to do with anything that had or now as being brought in the circuit court case, and then a separate provision that releases claims, insurance claims, and says, well, definitely releasing this one, but any other one you have now is also released.
With respect to the claim number that is specifically listed there. And I understand what
No, it doesn't say, no, not with respect to, it says including but not limited to that claim number.
I understand what Your Honor is saying, but when you look at the case law with respect to general releases, and you look at the Board of Trustees, which is the 4th District Court of Appeal decision cited in our brief, the State Farm versus Nichols, Florida Supreme Court 2006 case, and then Allen versus Nunez, a Florida Supreme Court 2018 decision, the courts are very clear with respect to these broad form releases that such language is permissible, and that the Florida Supreme Court has said that we don't require the elimination of every ambiguity, only reasonable ones, and that, quote, courts are discouraged from nitpicking proposals for settlement to search for ambiguity. And that's the Florida Supreme Court in Nunez citing the circuit's decision in Carryall Transportation versus Newby, a 2nd District 2008 case. So since 2003 and all these reported decisions, and again, as we cited them in our answer brief, all stand for the proposition that a broad form release, which is the release that is attached to this proposal for settlement, is permissible, and that
does your argument turn on the fact that there was only one claim for coverage that existed at the time of the offer and the release?
That's correct. At the time that
let's say we didn't have that was something not in the record. What cases are there? Any cases that you've cited or otherwise in which there is a proposed release that says this claim for insurance, not counting a complaint, we know what we're talking about here, claim for insurance coverage or any other claim that you have right now is released? You have to release. In other words, you know what? This lawsuit had to do with your home flooded because of pipe burst, but if your garage burned down, you got to release that too.
Yes, Your Honor. In the Board of Trustees of Florida Atlantic University versus Bowman, the language in the release, and this is at page 508, describes that a release of, quote, the first party ever had, now has, or which any personal representative, successor, heir of a sign of said first party can, shall, or may have against the second party. And so I think that may have is sort of akin to the including but not limited to. And in this case, the Fourth District Court of Appeal said such a type of release is permissible. And this is why the Florida Supreme Court has discouraged courts from nitpicking settlement agreements, because again, the purpose behind a proposal for settlement is to encourage settlements. The appellant doesn't take any issue with respect to the 1.442 requirements as to what one would traditionally think of as a proposal for settlement. And for the first time on appeal is making arguments that it never made before the trial court. Now, I understand that this court in its de novo review can look at the proposed releases, but we do have to keep in mind under the Sunset Harbor case out of the Florida Supreme Court 2005, that the issue has to have been presented to the trial court. And in this case, the specific language upon which Ms. Arana is injecting this including but not limited to phrasing was never brought before the trial court. Now, we can reconcile this now at oral argument as we're doing now, but again, I think this goes outside the scope of the initial brief and those arguments. With respect to the March proposal, I agree with Ms. Berger that the trial court relied on the August proposal for settlement agreement. The fees were calculated from the August agreement, and therefore this court need not consider the March proposal. Other than that, I think that we will rest on the arguments made in the brief, unless this court has any more questions. But People's Trust feels very strongly that the release agreement does comply with Florida law, and that it does not seek to release future claims, which is what was argued down below.
Okay. Thank you, Mr. Rosenberg. Ms. Berger?
Yes, Your Honor, just briefly, with regard to the sort of preservation issue that council has raised, I would agree that at the hearing, really all that was discussed was the future claims issue. However, in the response to the motion for fees on record page 377, Mr. Rana did challenge the broad language of the release, and this particular provision, the including but not limited to language, is highlighted on that page. This was an argument that wasn't raised in the answer brief either. And as the council did bring up, your honors have de novo review here and are able to look at the proposal as a whole.
Real quick, the Board of Trustees case, it says, I guess I'm going to what you're saying. In other words, you're saying, well, you didn't just argue future claims. You argued that even if future claims were not extinguished, it was too broad. But under the Board of Trustees case, it said may have, the language, as counsel said, may have was fine. Any claims you may have, because it required the plaintiff to release the defendant for all claims which had accrued as the date of this execution. It did not bar any claims that the plaintiff may have after the date of execution, and that was fine. Could you respond to that?
Because in the answer brief, the Board of Trustees case was just briefly mentioned as a citation to in the Nichols case. Your Honor, I'm not as familiar with it as I am the other cases here, but I will say, again, when you add that including but not limited to language here in that second paragraph, it takes it away from what I believe is being argued by counsel here.
Isn't that the same as saying any claim you have or may have?
In this, the way that it's worded here, I don't believe so, Your Honor. I think that the way that it is, it has a particular provision that specifies this lawsuit, and a second provision that discusses any and all claims up to this point ever had or now has, including but not limited to this claim. So I think that takes it a little bit away from that general understanding from that counsel's argued. Or
well, let me ask you this. So let's say we maybe no one's even disagreeing on this, but I won't go that far because opposing counsel doesn't have another chance to argue. But let's say, okay, it's actually including within its ambit any insurance claim that the party, the offeree, has against the insurance company up until this point. Why isn't that consistent with this? Why doesn't it bring that? Why doesn't that bring this into the ambit of the fee shifting statute? In other words, why is it ambiguous? Why is there any doubt?
It's ambiguous because paragraph 3 of the proposal states that it resolves all damages that would otherwise be awarded in a final judgment against the defendant and in favor of the plaintiff in this particular action. It doesn't say anything else about anything that may exist.
Well, no, it says this action. Oh, and also anything else, any other insurance claim you have pending.
But it doesn't say that in the proposal. So the argument is that in the proposal, it's very specific, and the release broadens it to include any and all claims that she may have.
So what's your case of saying that type of ambiguity? But she had the release.
Correct, which broadened the scope of what the...
So taking it to its broadest, in other words, let's assume that the offeror meant it the broadest way possible, meaning not only claims that were the subject of this litigation, but also any insurance claim you have. And if that was able to be ascertained from the documents, she knew what she would be giving up. Then why I'm asking you why that takes it outside the ambit of the offer of judgment statute.
Because it's not sufficiently clear under the rule with regard to the terms and conditions. Again, if the proposal had said, this resolves any and all claims that may, if it had included the same language in the release, ever had or now has against People's Trust, we wouldn't have the same issue, but it specifically states the damages that could be awarded in this case. And damages can't be awarded to claims that aren't involved in the case. So I think
what you're saying is she didn't know. She said, well, this would be a really good deal if it was what was in the proposal, but it wouldn't be such a good deal if I go by the release. But why wouldn't you say, well, they said that in the proposal, but they also want all these other claims, so I got to assess this deal based on everything they said they want me to release. Well,
well, according to the case law, it's not her burden to make that determination or to make that distinction. The burden would be on people's trust to sufficiently state that with particularity and not have to have her, decide what that means. If there's any question in her mind, she's entitled to reject it because it's insufficiently particular. And that's based on the cases that were cited in our brief, Your Honor.
Great.
And I'll rest on those
Okay.
papers. Thank you.
You used your time. Okay. Thank you both very much. You can leave by pressing the leave button, which is in the lower right corner of the Zoom